All right, let me move on to the next topic. We've now established our practice. We're attracting clients. Some of them are paying clients. I want to ask you something about the practicalities of getting paid. What do you do about retainer agreements? This is going to be a compound question for convenience sake. What do you do about retainer agreements, payment plans, getting security for fees, like the assignment of bail monies or taking a mortgage on property, that type of thing?
You want to start?
You go first.
All right. If I had collected the fees that I've charged over the course of my career, I can assure you I would not have a mortgage, which I do. And I think all of us face the problem of uncollected fees, difficulties in terms of the collection of fees. We do have a standard form retainer that I think probably should be updated. We've had it for many years, and although we've tweaked it on occasion, I think it's time for perhaps to develop the American style of retainer, which is a letter retainer rather than a form retainer. But we have a fill-in-the-blanks specific retainer. And that specific retainer also has the opportunity to say what the charges are, what the initial retainer is going to be, what the hourly rates charged by various people who are going to work on the file might be. It has the provisions about withdrawal of services. It has the provisions with respect to collection of fees and withdrawing for failure to pay fees. And quite frankly, although it's there, I can count perhaps on one hand after 37 years of practice how many times I in fact have withdrawn my services. Because you become committed to a trial, you become committed to a client, you become committed to the fact that you have been paid a certain amount of money, and although it doesn't approach the proper fee that was to be charged in the circumstances, you have an obligation to fulfill, and you have that obligation to continue the trial to its logical conclusion. It even becomes more complex when you have huge trials. As I've been engaged in the last 5 or 6 years, trials that can last 15 months, one that was 15 months, one that was a year, one that was 9 months, one after another. Well, after you end up being in a 9-month trial that you anticipated was going to take 5, and you've been paid for 5, you can hardly then walk away from it. And then if you lose, it's difficult to walk away from the appeal because the client has already invested an enormous amount in the knowledge that you've gained, the disclosure that you've reviewed, the workup that you've made on every witness, and as a result, there isn't an alternative. It's not as if you can pass the file on when the files are enormous files. You become committed to them, and you have to complete them. And that's part of your professional obligation. I've never taken a mortgage on a client's home. I wish that I had, and I may in the future. Probably one of the saddest stories that I can tell is that, now I will tell you who the other counsel was in a moment, but there was a trial that wasn't a lengthy trial, a couple of weeks. It was in Brampton many, many years ago, and I had the person who, against whom there was the greatest amount of evidence, was first on the indictment. Certainly it was going to be my case to win or lose in terms of who at least was exposed to a possible conviction. The middle person had some exposure, not much to do, was there for the ride. The third person, I'll tell you who it was Paul Volpe was the third person, was only charged because his name was Paul Volpe, and knew that he was only charged because of his name. There was almost no evidence against him, and so Paul uncharacteristically went to trial without counsel because he was happy to see that I was in number 1 position and Earl Levy was in number 2 position on the other person. We had the trial, acquittals entered, they take us for lunch. We go with some hesitation, but we go to lunch. And after lunch, Earl looked at me and said, "What are you going to charge him for this?" and I came up with a figure. And he said, I think I'll do the same. Well, Earl was 10 years my senior, and although he had done half the work, he was perhaps entitled to the same fee, and so he charged the same fee. About 2 weeks later, Earl said, my client was such a wonderful client. 24 hours later, he brought in the balance of the fee. I had half my fee. I'm still waiting for the balance. So you never know. And matter of fact, and that client had offered me as security. He had said to me, here's my diamond ring. Why don't you hold on to it for security? And I, of course, said, no, don't be silly. Well, it's sometimes foolish to both be trusting and from a business perspective to take those risks.
The takeaway on that is take the ring, and during the break, I'm taking a collection for Brian. Eddie, any comments, or do you want another question?
What I can just say to you is that I find this a very difficult and painful area. The rule in our office is that if a client comes in on a first interview, you don't let me in the room alone with the client, because I'm a sucker for any story, and I never talk about fees. I don't like talking about it. I find that, somebody's coming in and giving you a tragic story about their involvement in this, and you're going to talk about fees. I'm not good at it. I'm lousy at it, and everybody knows it. And so the people I've gathered around me are people that do it. They can ask, they can talk about it. I'm uncomfortable with it, and I do not enjoy it, never have. My first year practice, I think I billed about $3,100 in the entire year. And I didn't seem to mind. My wife minded, but I didn't. It was okay. It was okay. And we actually talked about going back to Niagara Falls, or I did. And my wife said, well, why don't we just give it one more year and we'll see how it goes, and if it doesn't go well, then you go back to Niagara Falls. And so I've never, ever been, as I say, I once took on a case I had no business taking on. It was a legal aid murder case, but I happened to be in the office Saturday when the mother of the person who was arrested called up and came to the office. So as I say, I let other people do it. But I have rules. The rules are no mortgages, no chattels, no personal property, no nothing. I don't enjoy in any way taking cash, and I only prefer if they pay by check, or at least I tell the other people in the office that are doing it that I much prefer that. If we do take cash, we have 3 people who count it, triple count it, and so that there's no problem with it. But these retainer forms that are made up are not things that I'm comfortable with in any circumstance. And you have to get over it. I got over it by hiring people who have no problem with it. And that's how I got over it. Otherwise, I would be probably practicing out of some trailer in the east end of town. And that's the truth of it with me.
You should know, and many of you may know, that the great and distinguished G. Arthur Martin never discussed retainer with clients. His sister, Arlene, ran his office throughout his entire career, and she was a tiger. And she was the one that set the fee, collected the fee, made all the arrangements, and Justice Martin never discussed fees. On the other side of the coin, you should know, and Eddie said, the idea of the cash deposit, which is really problematic and is becoming more so with FinTrack and banking requirements in terms of although you don't have to disclose the client's name because that's privileged, just the idea of taking in cash to the bank becomes a difficulty. But I will recall as if it was yesterday, about 25 years ago, our good friend and colleague and friend from Niagara Falls, George Walker, phoned me in a panic one day because he had accepted a cash retainer and his assistant had dutifully taken it to the bank, and the police were outside his door because he had deposited counterfeit funds into his account. So that's also a consideration when you take cash.